Right to information is an important enactment which has enabled the citizens of this country to get information from the government as a matter of right. The central government and state government bodies and those which are the recipients of government grants come within the ambit of the Act. Also, the local bodies and even others which are controlled and substantially financed by the central and state government, including NGOs, are covered under the Act. Meaning, all these bodies or institutions will have to supply information if a citizen approaches them. The objective of the Act itself is to empower the citizens and also promote transparency and accountability in the activities of the government. Though many of you may be aware of the provisions of the Act, it will be useful to go through the important provisions to refresh them. I am Advocate Faisal. Information includes documents, memos, emails, circulars, orders, reports, samples, and electronic records. Any information pertaining to a private body which is accessed by the public authority also comes within the ambit of the Act, meaning that those information also will have to be provided to a citizen, subject to certain restrictions, which we will describe later. Now, all the information possessed by the public authority can be availed of by a citizen by submitting an application to the concerned authority. Information may be in the shape of documents, records, or those from which notes may be taken, inspection of work, records, or documents. Now, information can be obtained in the shape of photocopies or in the form of electronic records, like in the shape of a compact disc on which the matter is copied from the original record. Of course, provided these are available in electronic form. The information is available in electronic form. However, information cannot mean problems, interpretation of records, or hypothetical questions. The time period for the supply of information by a public authority is 30 days. But if the information concerns the life or liberty of a person, then it should be supplied within a period of 48 hours. Now, supposing an applicant approaches the wrong authority, or the application for information is submitted to another office instead of the proper one where it ought to have been submitted, a 5-day period will be added to the 30 days or the 48 hours, as the case may be. Meaning, what ought to have been supplied, normal case, within a period of 30 days, where the application has been submitted to a wrong authority, the concerned public authority will have a further period of 5 days to give the answer to the query. The same thing applies to information relating to a person whose life or liberty is at peril. Again, 5 days will be added to 48 hours, as previously mentioned. Now, at this stage, it would be useful for an applicant who intends to apply for information from a government or public authority to do a little homework. Now, it would pay well if an applicant submits one application pertaining to a particular matter. Now, for instance, if the query is regarding the construction of a road, all the additional questions regarding the construction of road can be included in that particular application. Now, for instance, the name of the contractor and his whereabouts. Secondly, the ingredients or the materials used for construction of road, the time period that it has taken to complete it, the fund which has been allowed for the construction, the expenses involved, the labor. Now all these matters can be included in one application itself under subheads, so that the applicant as well as the public authority is supplying the information much more easier for each of them to access the information. Now, whom do we approach to obtain the information? All the government offices have appointed assistant public information officers to whom the application can be submitted. And of course, on the submission of the application for information, the public authority has to issue a receipt for the same. And in case the applicant is not sure which authority to approach for submission of the application, he can approach the assistant public information officers of the post offices in the relevant area, and the post office public information officers will direct the application to the concerned departments or the offices as the case may be. Now, an applicant can bear in mind or ought to bear in mind that he didn't supply information as to why he wants to obtain that particular information. Meaning, the applicant need not express in the application as to why he requires that information. The public authority also does not have any right to demand as to why the applicant requires that particular information. The basic fee for information which has to be supplied along with the application form is ₹10, which can be paid through demand draft, bank check, or pay order payable to the accounts officer of the public authority concerned. Now, further fees can be paid. Now, in the case of A4 size paper, the charges would be ₹2 per page. In the case of a bigger size paper, actual costs will have to be provided. In case of models or samples also, actual charges will have to be remitted. In the case of a compact disc, ₹50 per disc has to be given. Now, we shall examine the exemptions that are provided in the Act, meaning information that need not be supplied to a citizen. Those include: 1. Information which would prejudicially affect the sovereignty and integrity of the country, the strategic, scientific, or economic interest of the country. Secondly, matters which pertain to privilege rights of the Parliament or the state legislature. Thirdly, deliberations of the Council of Ministers or secretary level meetings. Now, in the last mentioned case, so the deliberation of the Council of Ministers secretary, if the information officer is of the opinion that the overriding public interest requires such deliberations to be made public, then he may do so. Now, most of the information or records available with the government have a time period during which they are kept in custody, and after which they are destroyed. Some departments have 20, 30 years or even upwards, during which the records are required to be kept in protective custody. Now, in a case where such information, though required to be destroyed, have not been done so, and it is still available with the government, in such cases, the information necessarily requires to be made available to a citizen if a request is made. The applicant can prefer an appeal to the first appellate authority if he is not satisfied with the reply given by the public authority, or no information is provided by the public authority. The appeal itself has to be preferred within a period of 30 days from the date of receipt of order or the information supplied by the public information officer, or after the expiry of 30 days from the date of submission of application. The appellate authority, first appellate authority, will have to dispose of the appeal within a period of 30 days or at the most 45 days from the date of preferring of appeal. Now, an applicant not satisfied with the order passed by the first appellate authority, or where no order is passed at all within the time limit specified, can prefer a second appeal to the second appellate authority. Now, we may come across cases where information relating to third party, for instance, a private institution, data relating to a private institution which is available with the public authority, and information is sought for by a citizen. Now, in those cases, normally such information is exempted unless the information officer is of the opinion that the larger public interest necessitates such disclosure. And of course, before going ahead with the supply of information, the third party will be given an opportunity to defend his rights not to disclose the information which is available with the public authority. Friends, hope the information provided is of use, particularly information relating to activities conducted by the government, and citizens needn't be overawed by the quantity of information and the expense which it may involve in getting information. The provision for inspection of records is a useful tool whereby one can go through the relevant information, and having noted down the important ones that he can inspect later or go through leisurely, make an application for the certified copies or just copies of the important records alone. Friends, please feel free to comment and give instructions so that the material uploaded can be made more useful.